need legal advice, this presentation is not a substitution for legal advice. It is intended for general information purposes only, and laws are constantly changing. They can vary from court to court depending on what rulings have come down. And so if you have a legal issue and wish to learn more from a lawyer, you should take your specific facts to a licensed attorney in your relevant area and get legal advice for your specific issues. If you haven't already seen, there's a video called 10 Rules for Dealing with Police, which is created by Flex Your Rights. You can actually watch it for free on YouTube, and that's a great background video to understand your rights in a whole host of situations. We'll be having some crossover with that video, and we'll be going a little bit deeper than that video, but it's a great film, and it's a great organization that helps people understand how to deal with police. Starting just generally with the Constitution, we understand that the Constitution provides a Bill of Rights. Those are the first 10 amendments to the Constitution. And those Bill of Rights were originally dealing with the federal government, but they were eventually incorporated through the 14th Amendment. Incorporation means that it's been held against the states as a kind of floor or baseline of rights that people are expected to have no matter what state they are in. Dealing with close encounters, we're going to be focusing in on the Fourth Amendment and the Fifth Amendment. And the Fourth Amendment provides the right of the people to be secure in the persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And we're focusing here on unreasonable searches and seizures. Because when we talk about police encounters, we're talking about whether an officer has caused a seizure to occur by restraining your ability to move, in other words, telling you to stop or possibly arresting you, maybe even touching you or touching your private property, and of course related searches. You know, is an officer going into your pockets? Is an officer looking through your belongings? What constitutes a search? Those types of issues really come up when we look at police encounters. And we're going to be focusing a little bit more on the seizure aspect when we're talking about police coming to talk to you in the public sphere. I'm talking about the Fifth Amendment now. Also of importance here is that you shall not be compelled in any criminal case to be a witness against yourself or your private life, liberty, or property without due process of law. What this has gone to mean, generally speaking, is that an individual does not have to incriminate themselves. In other words, generally speaking, a person doesn't have to speak to police. A person doesn't have to offer up information. There are some certain exceptions, and we'll cover a couple of those in some upcoming slides. But generally speaking, on the street, you're not required to talk to a police officer simply because they want to talk to you. So you don't have to worry about that issue. Now, we're going to talk about probable cause. You've probably heard that, or PC for short, on lots of TV shows where there's, arrests being made and there's like courtroom dramas and CSI, things like that. You hear probable cause thrown around a lot, and generally speaking, probable cause exists where the facts and circumstances within the arresting officer's knowledge and of which they have reasonably trustworthy information are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. And that's very verbose and wordy and confusing, but the short of it is that probable cause is a standard that an officer has to reach in their knowledge when meeting somebody on the street in order to make an arrest on the street. In other words, an officer has to see these facts and circumstances at a reasonably trustworthy level related to criminal activity in order to make an arrest. So the short of it is an officer on the street is not going to just be able to walk up to a random person and throw them in jail. That is a part of due process that is protected and incorporated through the 14th Amendment, which states are required to provide. Reasonable suspicion is going to be another point of topic upcoming, and so I'm just making these definitions clear. A reasonable suspicion is a lower standard than probable cause, and that's often where we hear that whole Terry stop idea. If you ever have seen someone just stop in the street and then you see the Terry stop pat down, that typical officer patting somebody's outer clothing down, that's what we think of when we think of a reasonable suspicion stop. And a reasonable suspicion stop happens when officers have specific and articulable facts which indicate that a crime has been, is being, or is about to be committed. It's not as high as probable cause, but it's enough that officers see facts which make them think that a crime is about. And this has to be more than a hunch or a general suspicion. In other words, officers can't just say, oh, that person walking down the sidewalk looks suspicious. It can't just be, oh, that person is a minority and they have a backpack. I have a hunch that they have drugs. There's still a level of protection that has to be metered out when it comes to carrying out reasonable suspicion stops. And reasonable suspicion stops basically mean that an officer is able to detain a person, that is, tell you that you can't move from somewhere for a brief period of time. And that time period has depended on whether or not an individual is committing a certain type of crime, which requires a lot of investigation. On the short end, for traffic stops that some people might be accustomed to, those are supposed to only last, about 15 minutes at most. Someone that maybe doesn't have a bicycle helmet or bicycle light, and a city ordinance requires it, the officer's only supposed to write them a citation that should take 10 to 15 minutes tops, and that's it. That's all they're allowed to detain for with those types of short stops. And that being said, there are instances where an individual can be held for longer, and that is an example of that was a woman who was trafficking drugs and balloons inside of her intestines, you might say. The officers were able to hold her for about 24 hours. But again, that's an unusual case, and typically speaking, people can't just be held wantonly. There has to be a real logical connection as to how long somebody is being detained under reasonable suspicion. And of course, that carries also into writing citations, as I just mentioned. Now, talking about compliance on the street. The focus point, again, for this discussion, now that we've gotten this background information out of the way about your Fourth and Fifth Amendment rights, about probable cause and reasonable suspicions, types of stops, is that being approached on a public sidewalk or public place is the area that we're going to be focusing on. Generally speaking, police don't have a right to make you perform or provide anything until that probable cause standard has been reached, as you've seen. The exceptions that we're going to briefly talk about are where states have reasonable suspicion detention statutes, which allow them to, that is, officers, to demand your name, your birth date, and permanent address. What that really means, it came after a case that stemmed out of Utah, but the Supreme Court approved states allowing an officer who has, again, reached reasonable suspicion for a crime, not just walking up to you randomly on the street and saying, show me your ID or your credentials or something like that. They have to already be stopping you for a crime that they have reasonable suspicion about. If they have that, then they can ask those things. Florida is not one of those states. Florida is not a stop and identify state. In addition, just to note, you'll have to check with your local state, but generally speaking, the identification aspect doesn't mean you provide a state ID. You don't have to provide a driver's license, obviously, if you're walking, because you're not driving. So typically, identification just means stating your name, stating your birth date, and stating your permanent address. Of course, these things could potentially be challenged under the Fifth Amendment, potentially, saying that, it's incriminating to state your name. But as the case law stands, generally speaking, the Supreme Court has upheld that is okay for them to ask, and then if you don't, you might get a resisting/obstruction charge in states that have stop and identify. So, with that in mind, a person needs to establish what the officer is thinking or is doing before making a move to be safe. Because it's really important that whenever you're approached by an officer, you understand what the officer is looking for. Are they looking just to talk? Are they actually just trying to stop you and have a reasonable suspicion detention? Or are they about to arrest you? That's a very big deal. So what is your job? Your job is to be a detective. When an officer approaches you, your job is to figure out the circumstances about which they're approaching you. And of course, in your detective work, determine if it is safe to leave, because the safest thing to do is to get away from police. Consensual encounters versus detention/arrests. Police can obviously talk to you on the street. Police officers, just like any other person, that they can say hi, hello, how are you doing? They can ask you what's in your purse. They can ask you what you had for lunch. But an officer cannot, at least without the reasonable suspicion or probable cause requisite, they cannot make it seem like you are required to talk to them. They're not supposed to make you believe that you are under arrest or being detained with a show of authority if you're legally not being arrested or detained. Now, that being said, police can lie to you, but when it comes to legally operative words like an officer saying you stop or halt or you're under arrest, an officer can't really lie about that, because if they do say those things, it leads to issues such as a false arrest potentially. It leads to false detentions. It could lead to evidence being suppressed because the evidence was gained unlawfully. So an officer, at least legally operatively speaking, can't be pretending like, oh, I'm stopping you, or oh, I'm going to arrest you, and then saying just kidding. Once those levels are met, once an officer says stop or halt, and a reasonable person believes they're being stopped or possibly being arrested, they can't unring that bell. So we have to find out what that police officer is talking to you for, so that you can know what to ask next. So when the initial encounter, if you're approached by an officer, your first job as a detective is to determine your status. And the easiest way to do that is to ask, am I being detained or am I free to go? And remember to remain calm and still. You don't want to make an officer nervous or anything like that. You want to make them realize that you are confident in yourself, that you know your rights, but without, being really pushy or aggressive. You want to be firm, but you want to, seem very level-headed. And by asking, am I being detained or am I free to go, you are immediately establishing that you are not interested in talking to that officer, because you're trying to figure out whether you can actually leave. And so you're trying to make it clear that you are getting out of that situation. And if an officer continues to be evasive or not give you a straightforward answer, that could lead to a potential detention happening. And that is by the law. And so if that happens, that could be a lot of big trouble, because anything the officer says or does afterwards could be suppressed, because it would be an unlawful detention if they didn't have reasonable suspicion. And not only that, there could be civil damages if a lawsuit was successfully launched. So if the officer then says that no, you're not being detained, immediately this should be your cue to get out of there. Now, it doesn't mean that you should start, running full speed the other way, potentially arousing some sort of suspicion or nervousness. Now, that being said, there's another issue which we won't be talking about today, and that's, what fleeing from an officer can turn into reasonable suspicion. We're not going to talk about that, but generally speaking, this is just a safety measure. It's a good practice. You just say, thank you and good day, and walk away calmly. Why? Because you're just letting them know you're not interested in talking, and you're getting out of there in a safe and decent manner. Nobody can say that you were disrupting the peace. Nobody can say that you were threatening anybody if you walk away calmly and confidently. And that's really key. You don't want to cause any more conflict that you need, and you want to create the best possible case for yourself in the event that your rights are violated. Just plain and simple. However, now, if that officer then does say, yes, that you're being detained, you're in a different world, and your detective hat has to be tipped up a little bit more, because you have a lot to research. First, what you need to find out is why you're being detained. Ask the officer straightforward. Why are you being detained? It's important to know what exactly you're being detained for. Why? Because that could be used against the officer later in court if the officer ends up, saying something different. If the officer tries to pretend that they detain you for one thing but really was another, that could be a huge impeachment aspect. Especially where officers are making things up or trying to, play that they can do anything. And I personally have been in those situations where officers have tried to do that to me. Very irritating, even while in law school. So it's really important to make sure that you get them on the defensive, not in an aggressive way, but in a logical way. You're letting them know that you're building a case for yourself, and you're going to get to the bottom of this. If the officer then says anything other than, and we're talking about from Florida now, for loitering or prowling, and loitering or prowling is just an interesting issue in Florida. It's not, it's one of those things where you have to show your ID or anything like that. The issue with loitering and prowling in Florida is that one of the circumstances around which there's suspicion is refusal to state your name and address with loitering or prowling. However, stating your name and address is not an element of the crime. It's a really very intricate legal issue, but the short of it is we're just going to focus really more on what you need to do generally. Okay, so when the officer responds to you, maybe they said, oh, we heard that someone was, maybe if you're a young person, underage drinking. We heard something about, somebody tampering with a car. You don't respond to any of those things. You're just there to receive that information so you know for the future what it is that they were looking for. Next, you need to get their badge number and name. Why? Because generally speaking, in police procedure manuals, they are supposed to give you their badge number as a way for the public to know that they're a real police officer and not an imposter. So it may be difficult to actually take that information down. Obviously, do the best that you can, but try to remember their name, try to remember their badge their badge number, the badge number of the officer, and that way you have it for the future in the event that you need to file a complaint or file a lawsuit. asked to speak to the supervisor.